I dreamed it all ever since I was young. They said I won't be nothing. Now they always say congratulations. Worked so hard, forgot how to vacation. They ain't never had the dedication.
Guys, Dave with WGS here, bringing you kind of an important video. This is why I'm dressed up, and to kind of show the seriousness of this video and to bring some light on the subject. Just background on me: I have a bachelor's in political science from SIU. Attended John Marshall Law School, and since I can remember, I've always wanted to be involved in politics and run for office one day. That is my main goal in life, is to be involved and to kind of understand where society is and to understand what needs to be done and to run. That's really what my main goal is ever since second grade. I know, I was a weird child. But today, I'm going to read a paper I wrote on the Second Amendment. And I really want this to, go viral, so share, please. I think it needs, the population needs to be educated again on the Second Amendment. And I'm also going to provide a link to this paper so you can kind of read it yourself and check the sources and things like that. So, feel free to read the paper and then comment as well on the video. Again, I'm trying to make this video so everybody kind of understands the Second Amendment and knows what needs to be done. And what I'm really focused on is politicians taking accountability. Like this new proposal that was just amended, proposed to amend Criminal Code 2012 of Illinois, and it's up on the House right now. It's 1465, I believe. I will double check that, and I will provide a link in the description as well. And I mean, it's a total violation of the Second Amendment and of your rights. And these politicians need to be held accountable. It seems like no accountability anymore is okay. And I'm not all right with that, and you shouldn't be either. Accountability is the thing. Now, if these politicians were accountable and imprisoned, I think they should be imprisoned for the kind of bills that they're proposing. It is a clearly violation, clearly against the Supreme Court rulings, and clearly against your rights. And they think that they can pass this and, oh, no big deal. We're just going to let the Supreme Court figure this out for us. And no, that's not how it should be. If you try to propose a bill, you should understand it fully, and you should know the consequences of passing that bill if it's not legal. And that's what needs to happen in this country, and that's what needs to happen with these politicians. They need to be jailed. If you pass a law or try to propose a law that is unconstitutional, you should go to prison. I can't break the law. You can't break the law. Neither should they. We, the people, are the fourth branch of this government, which is what I'm going to propose. And we are the most important branch in the hierarchy. And we need to take action, and we need to hold these politicians accountable. So please stay tuned. I'm going to read the video, or I'm going to read the paper for you guys, and I want you to comment on it, and I'll kind of give some more ideas, and I have some graphs and charts and stuff in the paper as well. So let's get started. A Right or a Privilege, the Second Amendment, by David Mock, and my email is channelwgs@gmail.com. What I'm really focusing on here is the analytical meaning of the Second Amendment. Do citizens have a constitutional right to own and operate firearms? That's a big question here. The big question now, especially with, this Florida shooting that the liberal media just seems to want to cover constantly and try to take our rights away, and I refuse. I refuse to have any rights taken away. You should refuse too. We should not allow any kind of craziness like that to go on. We fought in this country, and we still fight for our rights, and we should refuse, and we should hold these politicians accountable, and they should be jailed if they break the law, just like I or you. So, again, let's get started. I'm going to read what the Second Amendment states. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment has brought about many debates over the years. Politically speaking, there are two sides to this debate, and that's the conservative side and the Democrat side. I'm going to explain why the American citizens have the constitutional right to own and operate firearms and carry firearms in public. I'm going to do this by discussing the Second Amendment and breaking down the words and defining the actual meaning of the Second Amendment, which nobody seems to do. I'm going to discuss our free market economy and how that plays a role into the Second Amendment. I'm going to talk about modern guns. I'm going to talk about arms and history. And I'm going to propose the idea of a fourth branch political system of checks and balances, which is, in fact, a thing. So, let's get into what the leftist interpretation of the Second Amendment is and how they understand it. The leftist interpretation is based off the first clause, the first sentence I read there, a well-regulated militia being necessary to the security of a free state. So that's like the first clause, which is understood by them that the right is a state right to arm the people when in service of a state militia. They take this view with the idea of a preamble clause in the Second Amendment. The first part of the amendment outlines the rest of the remaining amendment. So what they're saying is, here's the first part of the clause, right? So everything after that involves this first part, meaning that everything after that first sentence is kind of like a subsection. So yes, the military has rights to arm the people. It goes like, so, here would be the first clause, and the second clause would just kind of be, secondary to those, and they just kind of explain what they mean with the first clause. So basically, the leftists do not separate the statements, only providing states with the right to bear arms. So that's it. That's what they're saying the Second Amendment is. It gives the state a right to bear arms. The interpretation does not allow for individual right to own firearms nor operate firearms unless in service. This view deems that firearms are a privilege and can be regulated easily on the individual level. Again, the other interpretation is a conservative view based on the operative clause, which outlines the individual's right to own and operate firearms, not related to militia service. This view considers firearms as a right. The two views interpret the amendment as two different clauses, and therefore, or the conservative view interprets the amendment as two separate clauses, and therefore different statements, which are not necessarily related. So that's kind of the premise. This is whole thing. Nobody seems to understand where this premise is and how people can be so divided on this subject, and that's kind of where that division comes from. So now I want to talk about the ways to get rights in the United States. There are 4 different ways to get individual rights in the United States. And those are inherent rights, inherent powers, common law, and of course through the Bill of Rights. So that's 4 separate ways to get individual rights in the United States. There are 10 rights that the government was forbidden to regulate or outlaw. So that's the Bill of Rights. Those were like the first 10 that they decided that there's no way the government should outlaw or regulate these specific things. And that's how important the Second Amendment is. I mean, that was the second thing. They're like, we need to write this down now before they even get, farther down. And which is why it needs, and basically this is why it needs to be understood. I mean, this is why we need to analyze the Second Amendment and understand it, and not only for, you, but for the politicians. They should have done this. This should have happened already. They're breaking the law, and people are okay with it. I think they should be jailed, and that's why this needs to be outlined, and this is why I want to run so badly for a political office. I really would love to be a senator or a governor to really, push these issues and to get people to understand and to make sure these politicians understand what is going on. This is real life. This is important. This is your job. I know that I can't slack on my job. I know you can't slack on your job. How can you half-heartedly go into something and be like, oh yeah, we're going to pass this, but we don't necessarily know what it means or understands it? Makes no sense. So that's why it needs to be analyzed and understood today, right now. That's what I'm doing. So let's just go over these 4 different ways of getting rights in the United States, and I'm going to kind of go over that right now. Let's first start off with inherent right. This is a permanent right that cannot be transferred or surrendered, and something that a person is born with. These types of individual rights are not necessarily enumerated in the Constitution, so they're not necessarily written in the Constitution. It's just kind of like a common sense thing that the Founding Fathers thought, hey, we don't need to write this. There's no way they would take this kind of stuff away because it's just common sense. You're born, you get these rights. Inherent rights. A power that inevitably derives from an office. Okay, so this is something, or inherent powers, I'm sorry. Not inherent right. Inherent powers is the second one right now. Inherent right is just something you're born with. Inherent powers is a power that derives from office, position, or status. Powers that normally these are associated with powers that Congress and the president need in order to get the job done right. An example of this inherent power is the president's sole power to deal with foreign affairs. So only the president is allowed to deal with foreign affairs, and you're probably like, well, okay, that's fine. We always heard Barack Obama, and then now you have Trump dealing with these kind of international affairs. Well, where does this come from, right? The executive power, this is in the Constitution. The executive power should be vested in a president of the United States of America. So that's it, the executive power. That's what it states. And this is the executive vesting clause, if you want to look it up. So this power was traditionally wielded by executives. So when they say executives, you're probably like, okay, yeah. And that means kings and queens of England, basically there. That's what it is, kings and queens. So since our Constitution says that the executive power shall be vested in the President of the United States, that's it. That's the only person that gets the executive powers. So kings and queens of England were executives, so therefore they had all those kind of powers to deal with international relations and do certain acts. So therefore, the president inherited these powers from previous people or entities. That's it. That's what it is. So these two seem very similar, but they're completely different. An inherent right is gained through coming into existence. It's that simple. Just being born grants these rights to an individual. Inherent power is a right gained through the use of that power. So that's you, because somebody used that power or you used that power in the past, that gives you the power. This principle is used by the courts to deal with diverse matters over which they are thought to have intrinsic authority, such as procedural rulemaking. That's 1. 2, internal budgeting of the courts. And 3, regulating the practice of law. And 4, general judicial housekeeping. So, the courts use this, Congress uses this, and the president uses this thing as inherent powers. All three branches have inherent powers, and it's not stated in the Constitution anywhere that they have these powers. They just figure, hey, we need these powers to function as an entity, and we've used these powers in the past, so therefore they're ours. So the third way to get rights in the United States is called common law. Common law, okay, so let's define common law. It's basically based off societal customs of precedent, which was an earlier event or action that is regarded as an example or guide to be considered. Precedent is used in the United States courts to this day. That's how things work, precedent. So if the Supreme Court rules on something, that sets a precedent. So therefore, all the lower courts should have to follow that precedent, but don't necessarily have to, but they should, because it's based off a custom that you follow the hierarchy of the system and you do your job and you make sure you do not break the law. So that's basically what's going on. These lower courts, like in California, are making up these crazy assumptions and breaking the law because they're not following common law. They're going off on a tangent. It's crazy. I also want to say that a lot of our rights and common law and the way that things work come from England. Like inherent powers, it is based on societal customs that the courts recognized and enforced by judgment and decrees. So there's another thing that comes from England that we use. And the fourth, but not least, is the Bill of Rights. This is the first 10 amendments in the Constitution. They were created in response from several states for greater constitutional protection for individual freedoms. So, that's what they were created for, individual freedoms, and how the leftist interprets that as somehow the amendment was given states power makes no sense, because these were created for individual freedoms, and everybody can agree with that because it's true. The Bill of Rights lists specific prohibitions on governmental power, therefore grant people the individual right that the government cannot take away. The Second Amendment is an example of one of these freedoms that government cannot take away. That's it. That's simple. Cannot take away. The right to bear arms is not granted by the Constitution. Neither is it any matter dependent upon the instrument for its existence. The Second Amendment means no more than it shall not be infringed by Congress and has no other effect than to restrict the powers of the federal government. Okay, so you're asking, what is that? That is a quote. And that is a quote from an 1876 court decision in the Supreme Court, United States, versus Cruikshank. I don't know if I'm pronouncing that right. Hopefully it's close enough. Cruikshank. So let me read that again. This is a specific quote, and it's taken from the ruling. The right to bear arms is not granted by the Constitution. Neither is it in any manner dependent upon the instrument for its existence. The Second Amendment means no more than it shall not be infringed by Congress, federal government, and it has no other effect than to restrict the powers of the federal government. So basically, it's just saying that the right doesn't come from the Second Amendment. It's just saying the government can't do anything about that. They can't restrict firearms. Now you're probably thinking, okay, well that sounds more like a leftist interpretation, correct? I mean, 1876, and this ruling has been cited for over a century by supporters of restrictive state and local gun control laws. So you're right in that assumption, such as the Sullivan Act. But let me just enlighten you a little bit. At this time, the incorporation doctrine in U.S. law was not applicable to this case. So the incorporation doctrine is a huge, huge issue nowadays. When the Bill of Rights was ratified, rights applied only to federal government and to federal court cases. States and state courts could choose to adopt similar laws, but were under no obligation to do so. This is not the situation anymore, due to the 14th Amendment and the Due Process Clause. So, the 14th Amendment says that states are bound to the Constitution as well, and it does not only apply to the federal government. So that's a huge thing, and this was affirmed with the 2010 court case McDonald v. City of Chicago. We therefore hold that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. So, right there, Second Amendment fully incorporated in the 14th Amendment. That's the ruling from the Supreme Court. Therefore, states have no right to put restrictions or laws against firearms. That is now a federal matter, and it would have to, even then, wouldn't hold water because they're not allowed to regulate those. So, and again, look these up yourself. So, what is fully incorporated? I think that this is the real part, the really important part. The First Amendment, the Second Amendment, and the Fourth Amendment. And again, I'm going to have like a little chart right here. And hopefully, you kind of look at it, and it shows the full incorporation, partial incorporation, and no incorporation as of. It's like the most important part. Sorry about that. That's my dog. Arrow. So, sorry about the dog interruption. Let's get back on point. Arrow. Second part of that Supreme Court decision in Kershank tends to get overlooked. And I think it's the most important part, and I don't even know how the left side could cite such a court case when it tells them that they have that their view holds no water. And the second part of that, in quotes here, let me go over it. Neither is it any manner dependent upon that instrument for its existence. Let me repeat that. Neither is it in any manner dependent upon that instrument for its existence. So instrument. Let me define. Now, let me just kind of break that sentence down so we're on the same page here. Instrument. Okay? That is referred to, like the instrument, what they're saying the instrument is in this sentence is the Second Amendment. Existence being inherent powers or inherent rights. So, we kind of talked about that previous, inherent powers and inherent rights. So, an instrument, so it says, neither is in any manner dependent upon the Second Amendment for its inherent powers or inherent rights. That's basically what they said. Therefore, the Supreme Court in this circumstance stated that the right just exists. That's what they're saying. The right just exists. And is not reliant upon the Second Amendment to give that right to bear arms to individuals. It could not be more clear with the quote I just stated and how I broke it down. It's that simple. Inherent right. So let's kind of talk about what that means. Okay, so now let's break that down further. Let's go back to inherent right. Inherent right is easy to understand when applied to this ruling because the word existence in the quote. Any other word could have been chosen, but this word specifically relates two rights that a person has because they exist, because they were born. So that's inherent rights. Inherent powers can also be applied to this quote. The people used their right to bear arms to start a revolution before the United States was even in existence. Therefore, another reason why the right is not dependent upon the Second Amendment. So that's what I'm sure some people are confused about that. You know, like, what do you mean not dependent upon the Second Amendment? There you go, inherent power and inherent right. We have it. Right, they stated it right there in an 1876 case. That logic is in compliance with the Cruikshank ruling. The ruling cited by so many anti-gun advocates is actually the opposite. It's a pro-gun ruling right there. It's a pro-gun ruling, and I can't believe that the leftists would try to say it's not. Now let's talk about this. Let's move on. The Second Amendment is hard to understand because there are two of them enacted, technically. I know, crazy, right? And I'll explain further. The one quote in the beginning is the one passed by Congress, okay? The one ratified by states and authenticated by Thomas Jefferson reads, "A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed." It sounds the same, right? But it's not. Therefore, what you just read is the actual Second Amendment. So what I just stated right there, and what you'll hopefully read, is actually the Second Amendment, not the one in the beginning of this paper. Now, let me give some background on which one seems to appear. All my political science books tend to follow the one passed by Congress. All the law books follow the one passed by Congress, also known as the leftist preferred version. And I will compare the two and discuss the differences, and also describe if those differences make an impact on the interpretation. So, I'm sure you're confused. What do you mean there's two Second Amendments, the one passed by Congress and the one authenticated by Jefferson in the states? Yeah, most people don't know this, and it's important to know. And I read it, and it sounds the exact same word for word, does it not? But there are differences, and I'm going to go over the differences between the two versions right now. So one of the differences is the M being capitalized to not capitalized. You're like, yeah, it's capitalization and punctuation that really drives what something means. And that's very important in your English teachers, and everybody's been beating that in your head, so you can't say it's not true. So, militia. Let's define what the word militia means. A group of civilians armed and able to act in an emergency situation that is defined by the people. Okay. A side note of that definition is the fact that the difference between people not capitalized and people capitalized is when people is capitalized, it means as a collective whole. When the P in people is not capitalized, it means on an individual level. The individual meaning is the way it is used in the Second Amendment, by the way. So it's not capitalized, it's lowercase, so individual. An example of when a militia acting is necessary would be a need for a revolution. So that's an example. That's what happened in the past. George Washington and all them. That was a militia. They were citizens, unhappy, and they weren't employed by the state or were in military service. They acted in an emergency, and based on this definition, an emergency needs to occur. So an emergency needs to happen. It can't just be like, oh, well, we're creating a militia because we want to. No. It needs to be an emergency, and a prime example of this is the American Revolution, of a militia acting in an emergency. They felt a need at the time that it was empirical. It was very important, and needed to take action, and that's what they did. The next letter of the word that needs to be analyzed, of words that need to be analyzed, is the S in state. The capitalized S versus the non-capitalized S changes the context meaning vastly. So, the one ratified by Thomas Jefferson, state was not capitalized. And in the one passed by Congress, state was capitalized. So, how can that vastly change? One capital letter vastly change the whole meaning of an amendment. And I'm going to go over that right now. So, state, capitalized. What is that? That's a nation or territory considered as an organized political community under one government. Okay? I'm sure that's what you were thinking when you read the word state in the Second Amendment. But I'm here to tell you that is not what that means. That word state is not what that is supposed to mean. It's not a territory. It's not talking about the states of the United States. The uncapital state is a particular condition that someone or something is in at a specific time. Example, being in a state of panic or a state of freedom. So, when I talk about state, and when you apply it to the Second Amendment, it's not about the United States or the territories. It's about your state, how you are, what's your present situation. This simple word vastly changes the meaning of the first clause of the Second Amendment. And that's the real first clause, is the lowercase, the state of panic, the state of freedom. The thing that you're feeling, the thing that's happening to you. That's what the Second Amendment was supposed to mean. This simple word vastly changes the meaning of the first clause of the Second Amendment, which I believe was originally a right to revolution. And, you know, this can be backed up very easily by facts, and if you look back, it is a right to revolution. That is the first clause of the Second Amendment. To ensure a free state. Meaning not a free state as in territory. And this can be proven by the fact that Thomas Jefferson was a huge supporter of Locke, and in fact almost copied his work word for word. It's simple. It can be proven that fast. Locke was the original source for the idea of revolution, insisting that people have the right to do so. The Second Amendment, first clause, is a right to revolution. Locke was the original source for this idea of revolution, insisting that the people have a right to do so. Here's a quote from the Declaration of Independence. So it's actually a important idea, and it's actually something that we founded our country on, and something that needs to be looked into and needs to be understood. Okay. But when a long train of abuses and usurpation, pursuing invariably the object of events, a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. So Jefferson, 1776, Declaration of Independence. And that's who wrote the Second Amendment. And that's what he was trying to do, is provide a right to revolution for the people. So, another example of this right to revolution being the first clause of the Second Amendment becomes evident with the examination of the word state and how well regulated it affects what state is supposed to mean. In Jefferson versions, the people have a right to revolution. A well-regulated militia being necessary to the security of a free state, to a free well-being. The conclusion would give the state... I'm sorry. Yes. In Jefferson's version, the people have a right to revolution, regulated, free state. In the second meaning, I'm sorry. I have a lot of notes here. Sorry about that. In Congress's version, a well-regulated militia being necessary to the security of a free state. Now with that S capitalized, the conclusion would give a state a right to sovereignty. That's basically where that derives from, and why we have to incorporation. That's why the incorporation clause came about, because these states felt they have a right to sovereignty through the Second Amendment, which is not true. The correct definition would give you the right to revolution. Sovereignty, which is derived from the word state and its meaning in Congress's Second Amendment context of the first clause, being a location in the United States that has a territory, and not the particular condition that someone or something is in at a specific time. Evidence that supports the idea of the first clause being a right to revolution is the fact that it says well regulated. Well regulated in the amendment. The only reason for this in the amendment would be to ensure that people are not rebelling. Now, rebelling is an opposition not to persons but authority. So rebelling is just chaos. It's not a revolution. Totally different things. Those are the differences between the two Second Amendments enacted today. The Free State Clause. That's what I'm calling it. The Free State Clause. And that's kind of, the first clause. So that's what I'm talking about. And that's really important. It's a right to revolution. That's what the first clause is. It's not talking about a state or a territory or giving them right to sovereignty. It makes no sense. Why would a state need a well-regulated sovereignty? It makes no sense. No sense. There is no discrepancy in the second clause, which ensures the individual's right to own, operate, and carry firearms. The second clause remains unchanged by the different versions, which can only be interpreted to say people, meaning individual, because it's lowercase, have a right to keep, own, and operate, that's what keep means, and bear, carry, and keep visible arms, which are guns, firearms, shall not be infringed. Act, which means to create a law, to limit or undermine something. Again, I will have this paper so you can kind of read through it. It's kind of hard to emphasize what I mean, but with the parentheses and, me showing the lowercase and capitalized letters, it kind of makes more sense. The analyzing of the Second Amendment this way makes it clear that what the words mean and what the bill was intended to do. This was giving the people the right to revolution and to protect the people's individual right to own, operate, and carry firearms without infringement. Plain and simple. Okay, so the second thing I'm going to discuss right now is the free market economy, and I'm going to talk about why that impacts the Second Amendment. Okay, so the free market economy provides more insight on the American citizens having the right to keep and bear arms. So what is a free market economy? A free market economy is a market-based economy where prices for goods and services are set freely by the forces of supply and demand and are allowed to reach their point of equilibrium without intervention by government policy, and it typically entails support for highly competitive markets and private ownership of productive enterprises. So that's what we have. We have a free market economy, and that's the Google definition. So you can't argue with that one, liberals. Life, liberty, and the pursuit of happiness is part of the people's free market. The government has no right in determining the goods we produce, sell, and purchase within the U.S. territory. The only determination deals with foreign goods, which the president has full control of. And that is a fact. Look that up. The government cannot interfere with the free market economy and what we sell here in our own territory. The arms free market has a vast impact on the economy and is the same reason people protect this right. It's a big economy, the firearms market. So trying to limit that or take that away from the people, you're talking about job losses. You're talking about maybe another depression. Not to mention the fact of a revolution if you try to take these people's... I know if my firearms are trying to get taken away, it's time for a revolution. And that's a fact. I mean, even though I love this country and I want to run for office and I would love to be president of the United States and impact this world in a positive way, things need to happen. I mean, they need to happen and they need to be held accountable. So, for instance, the idea of this too big to fail, where have you heard that before? Oh, that's right. Obama said that when Chevy was bailed out because of how big they were. They were too big to fail, he said. We have to bail them out. They're too big to fail. And that's not how a free market economy works. That was the argument used by the left. As Chevy collapsed, many other companies would go down as well. Many, they say. They say alone the toilet paper company that supplies Chevy, could be in danger. The water company, everything. There's so much. It's like its own economy. That's how big Chevy was. That's what they're saying. That's why they had to bail them out. So if applying this logic to the arms economy, $6 billion estimated in revenue generated by the gun and ammunition industry in the U.S., according to analysts by business research firm Hoover's. If Chevy is too big to fail, so is the arms economy. We couldn't afford it. It would hurt. It would hurt us, our nation. The less argument would then logically apply to the arms economy. Too big to fail. So that's how our modern free market economy applies to firearms. The market is just too big to fail now. Here's some important words that you hear in the media. Modern guns, clips, high capacity, assault rifle. Let me repeat those. Modern guns, clips, high capacity, assault rifles. So I'm sure a lot of people ask themselves, what are these words? What defines them? But that's not the important part. The important part is to know what these words are. These are all buzzwords intended to get people upset like a beehive poked with a stick. That's the only thing. That's what these words are. They don't mean anything. Nothing. Who's defined what modern guns are? Clips? What the heck is a clip? High capacity? Who says that's high capacity? Who's ruling on that? Assault rifle? That doesn't even exist. There's no such thing as an assault rifle. Assault is an action. There's only tactical rifles. You could call them a tactical rifle. I mean, that would make more sense. But they're just rifles. So, these words have always been used by liberals to give legitimacy to their argument, which has no legitimacy. That's the sad part. Another buzzword. They had muskets. They had muskets? Seriously? These are not logical defenses. I mean, in fact, it insults the intelligence of the Founding Fathers, and further, it insults the intelligence of the American people. How dare they try to take advantage of us with buzzwords, and how dare they try to insult us? How dare they try to take advantage of the American people, and how dare they try to insult us with these words? They don't apply. I mean, they're just buzzwords. It insults the intelligence of the Founding Fathers, and it insults the intelligence of the American people, individuals. They're insulting you by saying this kind of stuff and by getting you in an uproar over it. And I can explain that. I mean, it makes sense. You're saying, some of those things make sense, like they had muskets. Okay, well, let's just start off by saying technologies, are always evolving and improving, even back then. I mean, that when they had, I mean, that's just obvious. Everything was always improving. Technology was always going a step further. Everything was always advancing, even back then. So I mean, in fact, even maybe more back then. This defense implies people of the time were incapable of thinking in terms of evolution of technology and the ability to advance the capabilities of firearms in generations to come. And let me assure you, they were. And I'm going to explain that in another video when I talk about red light cameras and how it relates to driverless cars. Thinking in terms of evolution and technologies and the ability to advance the capabilities of firearms in generations to come. I mean, that's basically what they're saying they couldn't do. They had no clue where, no clue how they wanted to advance the firearm, and no clue what would make it a better firearm. I mean, that happened. It makes no sense. Individuals do everything like that. They'll be like, oh, well, this mouse doesn't work for me, and this would be better, to put a scroll wheel in it, or hey, who came up with these ideas for smartphones and apps? People come up with apps every day to make the smartphone better, and they're saying you're not capable of doing that because it's way out of reach. The human race imagination has always been ahead of its time. And our capabilities. That is a fact. In fact, most fiction becomes reality. To think people from that time which used arms on a daily basis, particularly the Founding Fathers, were incapable of envisioning a more capable firearm is ludicrous. Ludicrous! The Second Amendment does not state that firearms will not be infringed until they become too modern or evolved. A sentence like that could have been added at any time. And they could have said it like, hey, we're going to limit this, after 20 years, technology is going to get too advanced and maybe we should adapt or modernize the definition, which is not true. They never said it, never came out of their mouth, and they could have wrote it in. They could have, 100%. What the Second Amendment does say is the Second Amendment the Second Amendment does not state that firearms will not be infringed until they become too modern or evolved. But was not, because there's no purpose of the Second Amendment, and the responsibility of the Second Amendment creates a fourth branch of checks and balances. So, that was a mouthful. What did I just say there? The reason they didn't add that, when guns get too modern or whatever, it's because not only does the Second Amendment create right to revolution, it also creates the fourth branch. And you're saying, well, we never learned a fourth branch in school. That's because I don't even know why they didn't teach this, but it should have been taught, and it revolves around one of my favorite quotes where he talks about, I must go because those are my people and they are leaving. So the leader follows the people because they're the most important part. You're not a leader without people backing you and following you. So now let's talk about this fourth branch. Another fact that makes this point moot is the 2016 case of Collentino versus Massachusetts. So you're asking, what? Another court case? Yes, another Supreme Court case that proves this point moot. Modern guns, muskets, doesn't matter, whatever. The court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the Founding Fathers, and that the Second Amendment right is fully applicable to the states. Right there, plain English. These people are lying to you. These politicians in California, Illinois, New York, all these people with all these strict gun laws, they're lying. They should be held accountable. What they're doing is breaking the law. Plain and simple, breaking the law. They should be imprisoned. So now let's talk about arms in history. During the American Revolution, arms were used to establish freedom from a tyrannical government. The founding fathers would not then ban people the very thing, arms, that gave them, us, our freedoms we know today. The founding fathers would not want a tyrannical government imposing their unjust values on the people. Collective whole, it's capitalized there. Without giving the people, lowercase, individual, a means to protect themselves. The founding fathers would not do such a thing, and to imply that they would be a bold-faced lie, straight up. To say that, they wouldn't give you the right or them the right to protect against us. Are you guys crazy? We're going to take your firearms away. Ludicrous. The founding fathers would not do such a thing, and imply would be a bold-faced lie. The founding, not only would they give the people arms, but they would also give them the right to revolution, which is what we talked about in the previous thing, how the Second Amendment first clause is actually a right to revolution, not giving states, territories, a right to sovereignty. The fourth, and this is where the fourth branch system is where the people's power derives. So the Second Amendment is what gives this fourth branch power. I mean, because without arms, you have no power. You have no say. You're just sheep and cattle. Here an example of the hierarchy of in this system. Now again, I have this little diagram in this paper that you could look over, but it's the people, and then I have 3 arrows going down, and I name the other branches: the legislature, the executive, and the judicial. The power, and so they all have powers. These 3 branches that you're taught today, they all have powers, and they all have these certain things that they're supposed to do. So what is the people's power? What power? If we're the hierarchy, we have to have the most important power. And that power is the power of revolution. The right to keep and bear arms. This is the only power of this branch. So that's it. That's the only power we have. And you're going to give that power away? It's nonsense. It's the craziest thing I ever heard in my life. That is our power. That is the people's power. The right to revolution, the right to bear arms. The Second Amendment is the most important amendment in the Bill of Rights. Hands down. It gives the people the power over the other 3 branches. Otherwise, we have no power over them. That is our power. Would the executive branch, meaning the president, give up his sole power for international relations? I don't think so. Would the judicial system give up their power to budget and to make internal decisions? No. Would this legislature give up their power to create bills? No. So we're not giving up our power either. And you need to stand up and tell them that. In this fourth branch system, the people have the most power, hence why we are on top of the hierarchy. The other 3 branches have equal but different powers to themselves. Since we the people derive more power than the other 3 branches, we would not be void of rights that other branches have to perform their duties. We need to perform our duties just like they need to perform their duties. So it wouldn't make no sense to deprive us of these rights. We would not be void of rights that other branches have to perform their duties, such as inherent rights and inherent powers. Going back to that again, yes. The right or duty is the right to bear arms, the right of self-protection, and the right of checks and balances on the other 3 branches. Plain and simple. That is our duty as American people. The right to revolution and the right to bear arms, to make sure the other branches do their jobs with checks and balances. Everybody agrees in checks and balances. Do not give up your right because these politicians are trying to make you give up your right. Don't do it. Hold them accountable. Make them go in prison like this Madigan. Unbelievable. Should be in prison for the law or for the bills he's proposing right now in Illinois on February 28th, 2018. In conclusion, so that's the end of my paper. Let me conclude here and give you guys, just a flashback of what we discussed, and hopefully, you after I post this paper, you'll read through it and kind of, do your own checks and check out the sources and, learn for yourself. Honestly, that's the most important thing. In conclusion, we the people are the highest branch, therefore would not be void of the rights and powers that other branches have, through inherent rights and inherent powers. Since the people have had the right to bear arms before the American Revolution, it only makes sense that we have the right after. The Founding Fathers' Revolution gives the American people the right to revolution and to perform that duty of the fourth branch. Keeping and bearing arms is a must. Also, the right of the people to keep and bear arms is a check and balance of the other branches. Modern guns, buzzwords, theory proposed does not hold up to any amount of scrutiny. We as American citizens have the right not only through the Second Amendment, but through our free market economy and our right to life, liberty, and the pursuit of happiness. After fully breaking down the Second Amendment, it is revealed that no matter what the individual has the right to, no matter what, the individual has the right to own and operate and carry firearms. The only thing that changes is the right to revolution or the right of state sovereignty. The real convincing fact is the Supreme Court case in 2008, District of Columbia versus Heller. The Second Amendment grants people the individual right to keep and bear arms. Again, thank you for watching. This is Wheels, Guns, and Shoes, and hopefully one day you guys will have the opportunity to vote for me. And I really want to run for office. I feel like I could do this nation do this nation good, and really provide some great insight and get us going in the right direction again. All right, thank you.